conflict. Dov, thank you so much for joining us.
Thank you, Andrew, and thank you to Elnet and Think for inviting me. It's a pleasure to be here. Actually, I would be tempted to relinquish some of my time to hear Daniel present more, case studies of proportionality and Laurie to analyze them, because I find it fascinating, and we don't hear enough about that, whereas probably we hear way too much about the ICC, but we can come back to that later. So I have to start with the usual caveat, which is despite my many functions, I'm talking in my personal capacity here. So it's quite a broad topic, which I'm meant to discuss, the ICC. We could, as Andrew said before, it could take up many seminars. I'm just going to give a few pointers, a few elements for the discussion, which have already been addressed in part by Andrew in his introduction and Laurie and Daniel. But actually, and we did not coordinate that, but I had planned to start with a few words on legitimacy as well. It seems to be the word of the day, Andrew, because you were right to point out that there is a legitimacy battle going on, and I think it's really fundamental to understand how that plays out at the ICC, because the ICC, beyond being a legal process, is a question of narrative and is a question of production of legitimacy. It's a court of law. And as any court of law, it produces legitimacy and also illegitimacy. And in this sense, it is important to keep that in mind when addressing the relationship between different parties inside the court, different actors in relation to the court, and also to understand that this is something which is inherent in any judicial process, and especially inherent in any international judicial process. And in this sense, it's not specific to Israel. Let's be very clear. The ICC produces legitimacy and illegitimacy in every case it addresses, in every situation it touches upon. And it's irrespective of whether there is a desire or a conscious desire to do that. I hear a lot, and this is a debate I've had with a number of you over the years, on whether the office of the prosecutor is specifically choosing sides or privileging a narrative over another. And that might be true, but that's not the point. Even a purely impartial, independent, objective investigation will produce legitimacy and illegitimacy. Will construct a narrative that can be used by people outside the court. Whatever, even if it's the highest, best quality investigation, prosecutor, defense that you can imagine, you will still be able to say that, because again, this is inherent to the system. I think that's a very important point to make. One difference that you have with Israel, and again, that goes back to Andrew's point at the beginning, is that the allegations which are made against Israel, especially those in relation to settlements, are an existential threat to Israel. When in other situations, allegations can construct a narrative against a government, against a rebel group, there are very few situations at the court where the allegations actually can constitute the base of an existential threat to the state of Israel. By putting in doubt its right to live and exist on that territory. So in that sense, it is a very big difference. Now, a question that also has been in discussion since for many years now in relation to ICC, does that mean that the ICC should be ignored? Does that threat that ICC constitutes to Israel by the simple fact of allegations being brought to it means that you have to ignore the ICC? Now, there are many people who have different views on this. Again, speaking in my personal capacity, I've always believed that you shouldn't ignore the ICC, because it's a lose-lose situation. It doesn't mean you have to, agree with it. It doesn't mean that by answering it that you're giving it legitimacy. It means that you're abandoning the battlefield. The ICC will produce illegitimacy against Israel, if nobody goes there. The starting point is that it's going to be used by outside actors to delegitimize Israel. And I think that there is more to gain by intelligently, strategically interacting with the court than to just abandoning the battlefield to those who want to use the court against Israel. But that's a broader discussion we can have. Now, three general points I want to make about ICC and Israel. Now, the first one, obviously, and everybody knows, Andrew mentioned it, the pretrial chamber issued a decision on the 5th of February 2021, where it said that the prosecutor could exercise jurisdiction on the territory of Palestine, which it recognized as East Jerusalem, West Bank, and Gaza. Now, I won't go into the detail here about the criticism against that decision. It's mostly weak legal basis. It's over-reliance on UN, non-binding resolutions. It's kind of probably, inconsistent use of principles of law. On the one hand, saying that it doesn't deal with international law. On the other hand, referring to self-determination. It's complete ignorance of Oslo. There's a lot to be said about this decision. A lot has been said. But the reality is that today, the prosecutor opened investigation in the situation based on that decision. And I know this was one of the questions. The recent events do fall within the scope of that investigation. I think that there is little doubt that, should the prosecutor decide to investigate what happened recently with Hamas, that there would not be, for example, a requirement to, extend the investigation or to announce anything. It's just part of it at this point. The fact that there is a decision last February does not mean that the territorial issue is finished. I think that's very important to stress. The pretrial chamber issued, again, not so convincing decision. It was very careful to say that it's for just at this stage of the proceedings that this decision is applying. And I think that to believe that there's a territorial issue is not a live issue would be a mistake. And I think that, in the logic of pushing Israeli interests at the court, it's important to put it back on the table whenever possible, because you're punching holes in what is a weak decision. And honestly, in relation to my point before about interacting with the court, I truly believe that the decision is weaker because so many amicus intervened. So my amicus pushed the court to issue a bad decision, to stay away from certain issues, which it might have gone into, like settlements. The prosecutor was relying a lot on settlements to justify jurisdiction, and the PTC stayed away from that. So I do believe that the decision is weak because those who intervene before the court, force the judges to make mistakes. That's what you do when you intervene. And to answer a question which Andrew has already answered, in that respect, Hamas individuals would, of course, be liable to be prosecuted based on that decision and that investigation. So that was the first point, the relationship between the decision in February and the investigation. The second point is the question of the crimes. Again, I don't want to go in the detail of the list of crimes which both sides would allege against the other side. Just one general comment which arises from what Laurie and Daniel said is a criminal trial is not a human rights report. And as a defense lawyer, I've been confronted time and again with the prosecutor bringing in a human rights report, a UN report, in order to found his allegations. But it's not the same type, it's not the same quality of evidence. And this is something which would be a battle at the ICC time and again. And again, I take the example from Daniel where, you only have publicly available information. And publicly available information will mostly say how many civilians died, possibly. And even that would be in doubt. We've seen enough examples where there are allegations that civilians died and they might happen to be combatants, etc. So publicly available information gives a very bad picture of the situation generally, and even less of a good picture and a credible picture in the context of a criminal investigation. And the bottom line is, it's really difficult to prove an international crime in theory. It should be, because you have to go into the facts, you have to go into contextual elements, you have to go into the intent of the alleged perpetrators. You have a very high standard beyond reasonable doubt. You have, you need corroboration, you need You need, no, you can't rely on hearsay. I mean, the basic rules of criminal law normally require a very high standard, and international crime should be hard to prove. And this is where it's interesting, again, to draw the link, and it seems we're all on the same page. You know, the disconnect between the discourse, public discourse on international criminal law, and the reality of what an international criminal trial requires. It's like Laurie said about, you know, you're just comparing numbers in order to claim that there is a war crime. And the same way, sorry?
2 minutes to conclude.
Thank you, Harry. It's the same in an international criminal law setting. We have the same phenomenon. You know, you have a human rights report saying, we believe a crime against humanity occurred or war crimes occurred. But in fact, when you look at the evidence, it's not that simple. So there is this complete disconnect between the two. But in that case, you know, as a defense, the rules are protecting you. You know, there are rules of due process, there are rules of evidence, there is a presumption of innocence, which are meant to protect you. And if you're, you know, if strategically using them, you can draw something out of it. My final point, and I'll conclude on that, is the question of immunities. So this is one of my preferred topics, but obviously the International Criminal Court last year, 2 years ago, issued an appeals judgment on the question of immunities of heads of state of non-state parties, so in the case of Bashir. And obviously this is very relevant because the prosecution of individuals, you know, officials of a state, requires arrests and surrender. And so, you know, if the prosecutor were to move forward with arrest warrants of any type, we would need to revisit, and there are strong arguments against the case law at the ICC and things to be done domestically to you know, push back against any indication that Israeli officials would not benefit from immunities when they would be under ICC investigation. I see my time is up, and I'm happy to take any questions on all those issues.
Thank you very